All right, we there? Hello, hello.
I'm here.
All right, so who is Team Austin?
That's me. My name's Ryan, but that's my son's name.
Okay, gotcha. Where you from, Ryan?
I live in St. Pete, Florida, from
St.
Chicago.
Oh wow, St. Pete, Florida. That's completely the other end of the country.
Yeah, so I have to admit I'm a little bit easy. It's very easy to talk to somebody right now. That's I can appreciate that. The first time in 4 years dealing with this stuff, so it's very cool that I'm talking to you live. So I'm a little starstruck.
Oh, don't be that way. Don't be all starstruck. I'm not all that. No, we appreciate you joining in. So, are you litigating a case, or are you involved in a CPS case, or what's your issue?
I was a non-offending, non-resident biological father who my son was. I guess the case was opened up in Massachusetts against his mother. So I went to go try to get him away from them, and since that time, it's been about 4 years. I've been forced into being pro se. I had a bunch of court-appointed attorneys that all set me up basically for like 2 years. And when I realized it was too late, I had my kid here
Mm-hmm.
for a little over a year, and somehow they managed to commit some kind of fraud, and I wasn't there, so they just kept doing things without telling me. And then they came into my house with the local sheriffs, and
No
uh,
warrant.
yeah, no warrant. Have since changed it from emergency to like I voluntarily gave them up or something. So I handled my own appeal. It was totally sabotaged by court-appointed counsel at first for my appeal.
Uh huh.
Since it's been dismissed because of a lack of prosecution,
Oh my
and
god.
yeah, I they withheld the record from the clerk's office. I just got that attested to like last month, 2 months ago, and DCF never provided discovery, didn't give me any exhibits, never made any specific allegations to me. I was never any issues, protective concerns, but since they were able to keep the case alive somehow through like an ICPC or something,
Mm-hmm.
they managed to get access to my kid again. I haven't seen him in going on 18 months. I see him 3 days a week on a Zoom or like a FaceTime for about 5 minutes now each call.
So who's got him?
The maternal grandmother, she hasn't. They haven't. They've been blaming me for why they haven't done guardianship yet because of my appeal. But she's been behind the scenes causing a lot of these problems. She's directly responsible, but it's one supervisor basically.
Wow, that sounds like a nightmare, man.
Beyond, it's I'm glad to hear. I'm glad to see other people trying to do that. For me, like it's important for me to be an advocate for other people around me and seeing knowing what I
Uh-huh.
just went through, and I've been using like case text. I've crunched like a
Mm-hmm.
billion words already on this stuff,
Oh my
and
god.
just on this case, and I'm trying to understand, you know, how it could have happened, and now I'm being anything I do is like it's goes the other way. It doesn't matter what I do, what I say. The judge won't even listen to me. So I'm not
How
sure what.
how old's your son?
He's 5.
5.
Yeah, he just
So if you've been in this for 4 years, it started when he was 1.
18 months old. Yeah, the his mother left him in a running car somewhere in Massachusetts, like middle of winter with the windows down.
Oh
And
Jesus Christ.
it's been about 4 years since then. It was in March of 2020.
So you
And
said you were a non-offending parent, or were you guys separated at the time, or?
yeah, yeah, he was born here in Florida. Um, they took him and or excuse me, his mother and the grandmother took him up to Massachusetts. They were only there for like not even 6 months before it started. I've never lived there. I've never been a resident of Massachusetts. Somehow I'm clicked into her. They all. I have proof that they altered the 51A reports. At what time? And I used to be a document specialist for Canon, so I know all about how to trace and track and how I know where they messed up at. And I have
Uh-huh.
like I have all these points, but it doesn't seem to matter. It doesn't. The judge doesn't look at it, and they added me to it somehow. And since
Well,
that point,
as the non-offending parent, um, did you have private counsel up there, or was it court
no
appointed?
court appointed. They actually appointed counsel before they ever served me or gave me any allegations specific to me.
So
Just kind of
what were the allegations specific to you?
I wish I knew. That's the biggest thing. Is like they say various concerns and reports out of Florida because they had a private third party for profit subcontracted adoption agency checking in on me once a month. I didn't have a problem with them. There was no concerns. I've got court order. I've had custody order in Massachusetts, and then I got it transferred here. Like I opened one up here in Florida, and while I was doing that, they went ghost on me and then started filing into the case. I had never seen a permanency plan until just this year. I didn't know all of these things that were, going on in the background. They weren't even telling me. So they just say various concerns, housing or something.
So,
It's an interesting. There's a lot more to it, but
so what are you doing here in our group? Do you have plans to do like a pro se lawsuit or?
no, I don't. I really don't. It's way over. It's way beyond anything I can ever imagine. However, I know my experiences and the work I've put in. Like, basically, the last 18 months without a day off, I've been working on this,
Yeah.
and I know that there's something. It's beyond me. When I couldn't go argue like actually practice law. I would never expect myself to be able to do that. But
You might be
I have to.
surprised. You might be surprised. A lot of the people in this group, the reason they're in this group. First, just so you understand, we don't do any juvenile dependency work at all, or family law work, anything like that. All we do here at my place is we sue, typically in federal district court, sometimes in state court, but typically in federal district court. We sue the social workers and or the agencies involved in removing kids from their parents or placing kids in bad placements, stuff like that. Usually the type of case that we would see, sort of just based loosely on what you're describing, would be what we call either a judicial deception case. That's where the social workers are basically just lying to the judge to get their way. And there's another type of case we see frequently. That's the unwarranted seizure case. That's where they seize a kid from the family or either parent without any emergency basis to do so, and without seeking a warrant prior to the seizure. So those are the two basic types of cases that most of the parents in the group are involved in. And that's really what we do here, both in the group, on the Patreon page, and then, basically everywhere else. So I'm not sure, I guess the concern I have is I'm not sure there's really anything that we have to offer for you here if you're not going to do a lawsuit either on your own or together with an attorney or something.
yeah, I think initially I had planned to litigate this myself.
Yeah,
That's what. And you get into it, and you're like, "Oh man, this is a lot bigger, and maybe it's a lot." I'm taking on, like, right now. I've gone the grievance the policies, and I'm the ombuds person, and I've sent the complaints out to the boards and the judicial committee for conduct and AG's office, and all I get is AI generated messages stating that they won't take any action. They just
none of those people are going to do anything to help you. Your only real recourse is to file a lawsuit, and even you have to recognize in filing a lawsuit, that's not going to get your son released to you. All it's going to do is get you money damages for what the agency or the social workers did that was improper. So
I understand that.
Yeah,
that's really what I need to do as it is, because I've wasted, not wasted, I should say, but I've put a lot into this, and it's cost me almost, financially, it's cost me just about everything. Yeah. It's like I can't meet my, so at this point, I'm looking to first start to file something either here in Tampa Federal or right here in the county where they came in, lied to the police, lied to they only had the CPS people here for about 5 minutes one time, and then they came back without telling me. They came right to my house. I was out at the UPS store, sending in notice to them about my transferred petition for paternity. I know, I understand this won't get my son back, but at this point, this is where I feel I need to be, because I
Yeah.
followed along, but I'm more worried about maybe pitfalls versus, I don't want to go like short suit myself and go after these, these three people in civil, like district court here for civil litigation, when that's going to mess me up somewhere for a federal case, and this is much bigger. They have the last name is Saby, and it's in Massachusetts, a lawsuit right now, and it just made it past the like the immunity stages, I guess, and it's
What? Well, wait. What are you talking about? What's in Massachusetts right now?
there's another big lawsuit, and it happened. The reason why I brought that up is because there's the same month, the same 2 weeks. They're being sued right now for actions taken within the same 2 weeks. That's going on in federal court, and it's a similar type of thing. But I'm
Well,
sorry, I went off topic.
Did you get a copy of the lawsuit they filed?
I did, and 6 months ago I probably took it and tried to just swap out information to see what it would look like and how it would read through like a site checker,
Uh huh.
and it aligns fine. I even contacted the foundation, whoever's handling a counsel for them, and obviously they couldn't take on the case or something. And if I guess if I could find contingency coverage, or even like I would give them 60%. Right now, I don't even care. That's
Yeah.
That's how bad I want to get to them, because they're doing it to the kid and not me. They're keeping
Well,
him from.
they're doing it to both of you.
Yeah, that's right, and I know I can help some other people, and if for whatever reason I can get one thing I learned from here, I'd be grateful.
Yeah. Well, the best thing for you to do is probably do the Patreon, and I'm not sure what level. I think it starts at whether
I think I'm a hero's dose right now.
yeah. Which one is that? Is that like $8 or $12 or something like that?
It's $30 or something.
Oh wow! So you're at the top level. That's basically
I'm all in. I'm all in, man. I really am. That's not what's important to me. My important is the exposure that you guys
well,
are.
that gives you the $32 level. That gives you access basically to everything. To the extent there's videos, we did a few how-to videos. That gives you access to those. I think most important for where you're at and what you're doing is you have access to the briefs, that is the complaints and the law and motion materials. So what I would do is I would look at some of those with an eye towards using them as a template to draft your complaint. You'll notice that each one of them sort of tells a story in the general allegations. There's always sort of the form parts that really don't tell you much other than who the parties are. But the general allegations kind of tell the story of what happened. And then when you get to the claims for relief, that tells you the legal cause of action based on the story, based on what happened. So what I would suggest is you look through some of those complaints, with the idea that they would provide a template for you to write your story. Now recognize that you have a 2-year statute of limitations, so that's 2 years from each bad act. So you have to sort of pinpoint and figure out, okay, what was the bad act? When did it happen? And if it's outside that 2-year window, then you're barred by the statute of limitations. Now, another issue that you have is, what is the proper venue? Where do you sue these guys? Is it in Florida or is it in Massachusetts? I think that's going to require some research on your end, because your defendants all reside in Massachusetts, right? They presumably submitted false or fraudulent evidence or misrepresented evidence to the juvenile court in Massachusetts. And so my gut feeling would be the proper venue to sue them in would be in Massachusetts. But you'll want to double check that. Obviously do your own research, but that's my gut feeling.
No, I think that I appreciate just that guidance through that point, because you're right. It's very complicated, and they basically it was like, well, what he won't know won't hurt him type of thing. So they just went all in too, and when I raised issue to it, they just retaliated. I mean, I've had my local case out of here dismissed, denied and dismissed for a new trial. I got up there, they sabotaged my appeal by loading all these. It was like it's 10 against 1 every time I go into the courtroom. Everywhere I'm going with this situation, it's been
Yeah.
10 against 1, and it's a little bit difficult that I don't understand a lot of the legal theories behind it, but understanding the fact that if I simplify it, and I did read one of your, I forget, plus 50 others is what I remember the most about, is like the different workers or aliases or whatever. I read through that in the amended complaint that you did. That's as far as I've gotten so far, but
Okay.
so I have been trying to understand a little bit more of what it is. I figured I could get them here for something because they came here without authority. They tried to snatch them out of school, and then they called the police to have them come in my house. So it was like they didn't want anybody to know where they were here.
So did they have a court order when they did all this? I mean, it sounds like if
They
they're
had.
coming from out of state, they're not going to do anything unless they have a court order.
You would think so. I think that they were just that confident because they didn't know I was paying that much attention to it at the time.
You had a Florida court order.
They did not. I had a Florida temporary custody order in hand, in effect at that time, and
Yeah,
they came
but
with
but that's not my question. If they
Okay,
had
okay.
a Massachusetts court order permitting them to take the child, then they would have transmitted that to the police, and the police would have helped them, collect the child.
Yeah.
So that's the question. Did they have a Massachusetts order?
They had one that as far as the police report will say is that is a non-enforceable order. The DCF even says it was a non-enforceable order we brought to them, so they wouldn't accept it or enforce it. But yet they were the same thing. They had a Massachusetts emergency temporary custody order not to remove the child. They asked for it right at the end of the July 1st court date, right when we're about to hang up on the Zoom. They asked for it, I guess, and I asked for it. They stayed on with the clerk. They were supposed to send it to me, withheld it, and then it was the 4th of July weekend, and I didn't get that order even when I'm asking for a warrant or an order when they were in my house. They still refused to give it to me, and then she sent it.
So wait a minute. Let's go back. You said that
Sure.
there was a temporary custody order issued in Massachusetts while you were on a Zoom call.
Yeah, and it was that was Friday, July 1st, and
And
it was pending a
did you
hearing.
actually hear the judge say, yeah, okay, that's fine, granted, or words to that effect?
Yeah, essentially she said that because she goes, is there anything else? And then they went to DCF counsel after they had talked to me, and she goes, yeah, I'd like a emergency. It was all set up. It was like emergency order, custody order, and she goes, okay, yeah. And I said, Judge, what was that? And she's like, just stay on the line. The clerk will send it to you via email if you have any questions. Otherwise, it was scheduled for the 6th of July for pending a hearing.
Uh huh.
Okay, well, I'll wait for it. And then they never sent it to me, and they showed up here the morning of the 5th. And when I got the email from the lady later on that afternoon, she had sent it to her personal email address, and then sent that to the kid's school. So she had it. She just wouldn't provide it to me.
Yeah, I just wouldn't
Sheriff,
give it to you.
yeah, they were in my house threatening me like if I didn't give over my kid, they were gonna do criminal missing child charges. And the sheriff's like, no, I don't know anything about that. So it just got.
Probably what's going on there is they got an order, and then executed the order to remove the child. So you're gonna want to focus your energy on what facts, what evidence did they submit to the court to get that order,
Yeah, they withheld the reports.
and then is that whatever that evidence is, whatever those facts are, was it true or was it false or was it made up? Was it fabricated? What was it? And then my gut feeling is that's going to be where the heart of whatever case you have, that's going to be where the heart of it is.
Yeah, that's what I've been working on. That's where I spent that bulk of the billion words I said.
Now,
Running skills.
Now, when did that happen?
The removal itself,
Yeah.
July 5th, 2022.
So basically, you have until, well, actually, no, let's back up a little bit. When was it that they made whatever representations that they made to the court? When was that? When did they file that?
Okay, so they withheld the report, but technically it's not even docketed, but it's stamped as of May 20. 6th, and they withheld the report from the judge because they claimed the social worker was out for 6 months. And
Well,
so
wait a minute. If it's filed stamped May 26th, they didn't withhold it from the judge. It's filed.
oh no, it's sorry, my fault. It's stamped with the trial date, not the actual date of the would have been it turned in. So she called a 30-day report from that May 26th date to June 28th. And even that court date when they brought this in, they didn't tell me about it. I found out after a
So
sign.
hold on. You're confusing
Go ahead,
court
go ahead.
dates. Court dates with filing dates. I don't care what the court date is.
Okay.
What you care about is there'll be a filed date somewhere on the first page. Most states will put it in the top right corner of the first page. There'll be a stamp that says filed, and then it'll have a date in it.
Yeah,
So
the
what's your filed date?
okay. So there's the it would have been on the 26th, which says the file date that they put in there, but the stamp up from the clerk is from 11/4. It's 5 months later.
So it was filed on November 4th.
Yeah, it was actually used again another date too.
So what was filed before that July order was issued?
That one that was withheld, and then they wrote up
Okay,
another
and,
one.
hold on. Let's
Go
focus
ahead.
on the one that was withheld.
Okay.
When was that filed?
The one that was withheld was it just says 5/26 of the date of the report.
Okay,
Doesn't actually
so
court stamp.
May 26th then is going to be your presumptive cutoff date for your statute of limitations. You're just
Okay.
going to assume that they filed it the day they signed it. That's May 26th. So you had 2 years from May 26th to file whatever it is you're going to file. So May 26th is basically
6
a
weeks.
month. Yeah, 6 weeks away. So you need to get things moving.
Yeah,
You don't have any time left to mess around. You got to start drafting up your complaint.
yeah. If I file in state court, would it? I just and then I won't hog up the rest of your time, and I really appreciate just this part. If I filed in state and I went after for my, fraud and interference with custodial rights, because they knew I had a custody order, is that going to mess up? Let's say if I lose, is that going to mess up anything for a federal case?
Oh yeah, it'll be collateral estoppel against you if you lose. I'm not sure I would file something like this in state court. That you got to remember, if you file in state court in Massachusetts, then that's going to be the same court that issued the order to take your kid.
Yeah, they don't like me up there. They don't like me up there at all.
So
Um,
I would probably file something like this in federal district court in Massachusetts.
Yeah. Oh, so I couldn't. Okay, so in Mass. All right,
Yeah.
that's fair. I just didn't know if they broke the law by coming into the state, and if I don't want to focus on that. If it's worried more about the jurisdiction, just go bigger than that. Okay, that makes sense.
Yeah, I don't know whether they broke the law coming into the state or not. You're going to have to research that issue. But if they had a warrant, then all they really have
No
to do
warrant.
well, it sounds like they did. They had a court order. It's the same. A warrant's just an order to pick up the kid, and it sounds
Okay.
like the court ordered them to go pick up the child. So it's the same thing.
Yeah, it's all based on like misinformation and fraud. Basically false allegations. They wrote up a bunch of stuff like. They did it like they altered the time frames too by saying these things. So then the
Yeah.
judge is trying to catch up, and the judge gets in there and goes, "Well, I didn't get your last report from the last court date, and all this is all new to me, and I'm judging by this report. I'm granting him, the custody to DCF based on one report. It's in the order, but I had 2 custody orders before that. I had one in Florida and Massachusetts. Granted custody. It was a parental approved placement by the ICPC, so I thought it was all set. I couldn't imagine that they would just like come in and start violating people's rights, like walking in their house and
Well, this is the thing. It's not a violation of your rights if they had a court order. So I mean, just keep that in mind.
Okay.
Where the violation happened, if it happened at all, is what they did to get that court order. It sounds like they
Right.
presented untrue evidence to the juvenile court to obtain the order. So if that's the case, that would be your lawsuit. It's a judicial
Okay.
deception case. Those are the types of pleadings that I would look at if I were you on Patreon, and all of that stuff is up there and available.
Awesome. And
Yeah.
I really appreciate the fact that you're putting your work product up there and sharing this stuff with it, with people like myself. And, even when this is over or whatever is going to happen here, I still plan to be sticking around. So thanks for spending the time with me.
Cool. Yeah. Right on. Hopefully, you're able to get something from there, and it helps to push the ball down the road a little bit on this thing. But don't
Yeah, I hope so, too.
don't waste any time though. Get right on it, because you don't have a lot of time left before you blow your statute.
I have one more quick question for you before I go.
Sure.
Do I have to, when I'm filing this federal complaint, do I need to get really granular with like what the actual, like in the complaint, do I need to there's so many things that it would take 50, 60 pages just to get through
Well,
like a month or two of what they did.
you can get granular. Again, what I would suggest you do is go ahead and look at some of the complaints that we have posted there, because all of them have a judicial deception component, so that it'll fit. And see how it
Okay.
is that we did it. Some of the stuff they get fairly granular, and you may need to do that depending on how complex your situation is.
All right. Good deal. Thank you.
But you don't have any time to waste. You need to get right on that. I can't stress strongly enough.
No, I'm actually working on it right now.
Yeah, good. All right, cool. With that, I think Michelle G.
Thank you.
Yeah, no problem. Thanks for joining in. Michelle G., I think you were next in line. You got anything for us?
Oh, hi there, Sean. Not really. I need to know how to write a motion in limine for evidence class, but besides that, not much is going on with my case.
I gotcha. Well, for motions in limine, they're typically very short. The whole purpose of a motion in limine is to limit the scope of evidence presented to the jury, and you want to take care of it like outside the presence of the jury before trial even starts, right? That's kind of the whole purpose behind it. And they're typically very short and to the point. It's like this piece of evidence, say a misdemeanor conviction for kicking your neighbor's dog when your case is about an auto accident, right? What is the rule of evidence, the FRE, that relates to convictions? Is it admissible or not? Does it have to be a felony or not? Is it remote or not? What are the pieces of the puzzle that have to be in place to exclude it from presentation to the jury at trial? And then that's basically what you would write up in your motion in limine. It's going to say, hey, this evidence should stay out because, right?
Yeah. What about foundation if you're trying to get something in?
Trying to get something in? What, doing a motion in limine to get it in?
Yeah, what I'm doing is there's a fact scenario where I have to try to get some things in and exclude other things, so I have to address foundation and things like that. So it's all pretty confusing.
Well, it depends on what type of foundation you're looking for. I mean, obviously, if you're doing it by motion in limine, you're going to have evidence to establish that you have a proper foundation.
Yeah.
We don't normally use motions in limine. I don't know of anybody actually. I've even never heard of anybody using a motion in limine to establish a foundational component.
Yeah, this is just a test. It's a follow-up for a midterm if you want to get extra points on the midterm. And I got A's on all my other midterms and a B- on this one. So I need to do this follow-up assignment.
Oh,
And it's not.
Well,
Yeah, it's not.
If you think just for a moment, look back to the Latin. What motion in limine? What does that mean? That's to limit, right? You're trying to limit something. So just on its face, it doesn't. I suppose you could use a motion in limine to address the admissibility of evidence in advance, but usually the way it's done, if it's a foundational issue, is you put a witness on the stand,
Yeah.
And you try to lay a foundation. Did you see it? Did you touch it? Did you feel it? Did you hear it? Were you there? Do you remember it? Did you write it? Did you sign it? I mean, those are all foundational type questions. And then once you lay the foundation for it, then you can start addressing other admissibility issues. But all I've ever used motions in limine for is to exclude or limit evidence.
Yeah, I think that's what they're typically used for, but we have to argue against an imaginary prosecutor who's trying to keep our evidence out. So,
Oh well, that's different. That's a different question. If the prosecutor's trying to keep evidence out, so
yeah.
you're arguing. So he's doing the motion in limine.
Yeah, for part of it, we have to do a motion in limine to keep the prosecution's evidence out also. So it's kind of arguing both sides.
I gotcha. So you're doing an opposition to his motion in limine,
Yeah,
as well as a motion in limine of your own.
exactly. That's what it is.
Well, that's not a hard assignment.
Well, it's a bunch of different things, though. Like, I have to do maybe 15 different things, so.
Well, your opposition, you always are going to look at the FRE if you're looking at, motion in limine. What are the rules, right?
Yeah.
And then you're going to basically, there's going to be elements associated with each of his arguments to limit evidence, and what you're going to do is just attack each of his elements. And if they gave you a specific factual scenario, then
They did.
it's just like your bar exam. All the facts you need to satisfy the assignment should be given to you in your factual scenario. Your job then is to figure out what the law is, what the elements are that are required, and what facts you have that can address each of those elements.
Okay. Right, so hopefully it'll go okay. Otherwise, I don't really have much happening in my case right now.
Okay.
So if somebody else has questions.
Cool. Well, hopefully that helped you out a little bit.
Yeah, thank you. I appreciate it.
Sure, absolutely. I think Lawyer Up was next in line.
Hi, can you hear me?
Yeah, I hear you.
I don't have any questions this week. I'm just observing and trying to learn.
All right, cool. Right on. That's always welcome.
Thank you.
And questioner, you're next up. What you got?
So a few weeks ago, you advised me to go through the clerk's transcript when I got it, make sure it was complete.
Yeah.
So I got the clerk's transcript, or I got an electronic version of it, and there's definitely at least one document missing. I also noticed that there's this document that it's a confidential document, so it doesn't appear in the clerk's transcript.
Mm-hmm.
Other than like saying, it's pages, 60 to 64 and it's confidential. And I was actually given a copy of the document. So I feel like that's probably right since it's the right number of pages. But before it, there's something like 30 pages of what says it's cover pages. I think it's either before or directly after 30 something pages of cover page and indices. Like indexes, but indices. And the document, if it is the genuine document, is only 4 pages long. So I'm thinking 30 pages of indexes for one document that I didn't even know.
What are the indexes? What are the indexes of?
It doesn't really say.
Is it the index of the clerk's transcript? Hello? Huh, that's weird. Can anybody else hear me?
I can.
Huh, well, she just went dead.
I can hear you.
Well, she just went
Can
dead
you hear
then. Because I think she's...
There she is.
Can you hear me?
I can now. Are you on a cell phone or something?
No, I'm on my laptop, but I was trying to get the document.
Oh,
I was trying
weird.
to pull it up. And anyway,
It
okay,
cut out.
so that's really weird. Yeah, okay, so I'm just feeling like, whoa, that's a lot of pages that I you know, like I got the original document. It didn't have any indices with it. Like what's
Okay.
what
Is it you know, the clerk's transcript will always come with an index of all of the entries in the
right,
court
but that's
file.
at the beginning. But that's in the beginning.
Okay.
That's in the beginning of the clerk's transcript. And this is
Okay,
in the middle.
well-
It's right before this confidential document.
Okay, well, what's it citing? If it's an index, it must cite something. What's it say?
Okay, I'm gonna have to look at it, and I don't want to. I want to ask you my other question before I go try to pull it up again,
in case
because
it
you
cuts
lost it.
off.
I'm.
Yeah.
I clicked on my. I knew the cell phone did it. I didn't know my laptop did it. So my other question is just about these, just in general about these. When the court investigator does a report, and it's a confidential report, and it's not given to all the parties, at least some of the parties don't get it.
Mm-hmm.
But you know that it exists because there's an entry in the Register of Actions. So if there's like a full-blown evidentiary hearing trial and the court investigator is not called and nobody tries to introduce the document, then it's basically irrelevant, I would assume, and then it probably wouldn't have any relevance to the appeal. Is that right?
Well, I don't know. If nobody introduced it
Okay.
and the judge did not consider it in any way, then how would it be relevant? Now, if the judge, like as a matter of law, receives the report, reviews it, and makes decisions based on it, but does not introduce it into evidence, then I don't know. That's a different situation. I don't know anything
Okay.
about conservatorship law or anything like that, or even how they run those courts. So these types of questions, I'm just the wrong guy to talk to about it. I don't know. But logically speaking,
Okay.
if the judge did not even see it, how would it be relevant?
Okay. Because this is a slightly different situation where there is no evidentiary hearing. It's just, I don't know what you call a hearing that isn't an evidentiary hearing. I don't know what you call it, but just a regular hearing or a non-evidentiary hearing.
Okay.
So that everything was decided in a non-evidentiary hearing. So there was no opportunity to call witnesses. That report was never introduced into the file. It's not part of the public file. It's a confidential document. I designated these things thinking they might be helpful to me. But I still haven't seen them. And then I've got this crazy index, 30-page index for a 4-page document, which I'll look at in a minute. Well, yeah, it's just it's like, so like, what are these things? I mean, the code says the court investigator is supposed to go out and the court investigator is supposed to do this and that. And then if you read down to the bottom of the code, it says, but no superior court shall be required to do any of this until the legislature makes an appropriation. So it's all kind of...
Yeah, I don't know. That's
Okay.
That's a
All right.
completely different system, completely different area of law. I have no idea.
Okay, I'm gonna try to look at what the index thing actually says.
Yeah,
it's so bizarre.
I would, because it sounds to me like maybe there's a separate volume in the court file, maybe of sealed documents that's not public, and that may be the index for that second volume.
Oh, maybe you're right. Okay, it's because because the document itself is pages 163 to 166, but then it has cover page and indices 127 to 162, so that's almost 40 pages. But maybe you're saying that's the first confidential document, so that's where the index goes.
Yeah.
Okay, that would solve the mystery. And if I just want to confirm that, I would call the clerk at the appeals court probably rather than the trial court.
Well, it's the trial court that puts together the clerk's transcript, not the appellate court.
Okay. All right. well,
So
They-
the appellate,
I-
the appellate
I-
court doesn't really have any input there. It's going to be the
but
trial
they could
court.
tell me what it, you know. But I could say, is
Maybe.
that what it is? Okay.
Maybe.
All right.
I would think the better information would come from the trial court clerk. The appellate division.
They already, when I
of the
email
trial
them,
court.
right. Right. But when I email them, they say, if you have any more questions, ask the appeal court.
Oh, okay.
And the appeals court tends to be nicer to deal with. Okay. So it's just sort of like you have these incredibly vulnerable people. The court goes and checks on them once every 2 years. The report is confidential. I mean, I think it's an interesting question you sort of raise. Does it actually say the judge has to read the report? Like,
yeah, see,
I'm gonna have to
don't
read it
know.
again.
You're gonna have
I
to
have
look
to
at that.
read that
'cause
again.
If it's anything like, you know, the CPS stuff, juvenile dependency, then the investigator's supposed to probably be or act like the neutral eyes and ears of the court and just report everything they find out, and then the court will review that report and make decisions based on the contents of that report. Now, I don't know that the same is true with conservatorships, but I would assume so, because otherwise, what's the point of having a court investigator go out do
Exactly.
anything and write a report?
If nobody's going to read it, or if nobody's going to take any action on it. Yeah, I mean, but
Right.
I'm going to have to read it again because it's like wait a minute. Okay. And did I already ask you this about local rules?
I don't
If
remember.
if can a judge ignore a local rule? Like, if a judge ignores a local rule, is that the basis for can that be the basis for an appeal?
I don't know. I don't think so. Well, you're in state court, so I'm not sure. I know in federal district court, you've got the FRCP, then you have local rules, which frequently do not align 100% with the FRCP, and then you might have courtroom specific rules that may even be tighter, or in some instances looser, than either local rules or the FRCP. So I'm not sure in state court. I know that the rules of court, California rules of court, preempt pretty much everything, right? So you can't, the state trial courts can't like do something that's prescribed or proscribed by the rules of court, but I think they can do things that are like less restrictive.
But if a judge ignores a local rule or doesn't apply the rule,
I think it's
like,
gonna
is that the
again. It's
basis
gonna
for-
depend. Are you talking about statutory rules like the CRC, or are you talking about, you know, just conventions
No,
set by the
local rules.
Local. Yeah, I don't know if that's going to give rise to an appeal
local
or
court
not.
rule.
My gut feeling would be no.
Okay.
Yeah, my gut feeling
Okay.
would be no. That's not going to give rise to an appeal. But now, if they don't follow the CRC or the
Okay.
Code of Civil Procedure, that's a different story, because that's actually statutory law.
Okay. All right. Thank you.
Sure. Anybody else have anything else?
Hey, Sean.
Yeah.
All right. So originally you were like a software engineer or software before you
So
became an attorney, right?
that was so long ago. I was first, I started out programming. I migrated into hardware, and then ultimately into law.
Right. So you became an attorney, but you weren't like a juvenile dependency or CPS attorney at first, right? You were
Never.
business.
Not yeah, right. That's correct. I've never done juvenile or family or crimes, any of that stuff.
So somebody got a hold of you or got your attention, whether it was through your father or not. I forgot that was the first case or not. But they made you look into it. So, like, what did you do since you had no idea about any of this stuff? Like, what did you look at to be like, oh, these people's rights have been violated, and like maybe I should look this up? Like, what was your
Cases.
process?
Cases. The process was first listen to the story, and then just sort of thought, oh, this all sounds like bullshit, and said, okay, well, I mean, let's assume it's true for purposes of what we're doing here, and go do some research and figure out, is this a violation of law or not? And I read a lot of cases, and that was basically it. I spent a lot of time in the books.
And do you prep a lot? Because you seem like not to like, you seem to know it so extremely well that no one, no matter what anybody says, they can't fool you. Like, you'll always be able to get a response out of them and be able to go around what they say.
Well, what you're talking about there is, well, let's see how you put this. To be able to, basically beat somebody into compliance into a deposition, you kind of have to know the rules and their training and the policies. You have to know it at least as well as they do, if not better. And you have to have it there with you for them to see it, so that, when they start to go sideways on you, you whip it out and beat them over the head with it, almost literally. And you only have to do that a few times before they'll start just saying, okay, whatever you say. So part of that is interrogation technique. Part of it is just hard work, man. You have to study the stuff to be able to know it at the level that you need to know it at in order to speak intelligently with, people that are trying to hurt you.
Understood. So what did you just pretty much like study the law and figure it out, and you like kind of assumed, not assumed, but like planned what their answers would be and those type of answers and counteracted those?
Well, no, for the depositions, a lot of that is based on instinct. You develop instinct by reading cases, by looking at the treatises, by learning the law, learning the rules. You develop an instinct for it, right? And
Sure.
then when you get into a deposition, these people are snakes. They're going to be lying to you from the minute that they start talking about pretty much anything. So you have to, be able to react to their answers on the fly based on instinct, but supported by, whatever documents, the policy, the training, whatever you have, their reports, whatever you have in hand. And a lot of that's just, it's preparation, I suppose, because you have to know what's there. You have to know what you have. And then, I don't really know how to describe it. A lot of it's just, I don't make an outline. When I go into a deposition, a lot of people have long lists of written questions and, very detailed outlines, all this shit. And I find that that's more of a distraction than a help. So what I'll do is I go in with a blank piece of paper and a pen. I know basically what it is I want to get out of them, just based on my prep. And then when I start asking questions, they'll always throw out what I call hooks. They're kind of key words and phrases, hooks and hedges. And I'll write those down, just key words. I'll have a sort of an outline of their testimony that gets generated on the fly while they're testifying, of just key words and phrases that I find interesting or curious. And then once I exhaust a line, and I don't have any more questions about it, then I'll loop back to my notes and say, okay, what about this keyword or this phrase or this thing? And then sort of exhaust that line, always keeping in mind the ultimate goal of where I want this person to end up. I don't know if that makes sense, but
It makes sense.
that's kind of
You're
how
saying
I do it.
you don't do an outline, you kind of just pretty much do a lot of prep, so you know the policies, you know the law inside and out, so no matter where they go, you can
Yeah.
come back to it at the end. And like, do you plan on like trapping them at all, or it just kind of happens that way? Like some
Well, you know going into it that there's areas that are sensitive, right? There's areas where they know they fucked up, or they know they've been prepped by their attorney, number one, right? Their attorney's going to tell them, oh, if he gets into this, do that, or you know that's going to happen going into it. So there's additional preparation that I'll do in an area where I know there's going to be resistance. And yeah, there sometimes you'll set traps, right?
Well,
And a good example of that, if you've watched the series of depositions in Raffalina's case. Hey, questioner, can you go ahead and put yourself on mute? You're giving feedback. Thank you. Yeah, in the series with Duval versus County of Los Angeles, you'll see this several times in several of the depositions, where I ask the witness about Dr. Gill. I say something like, so if Dr. Gill were to come in here and raise her right hand and swear to tell the truth and tell us that mom was great and wonderful and everything you're saying is bullshit, what, she'd be a liar or something like that? And they'll say, oh yeah, that's not true at all, or oh yeah, Dr. Gill said XYZ to me and it's in my report, whatever they said, I don't remember exactly. But those are all traps. I had Dr. Gill, I'd interviewed her, I'd written up a declaration with her. She signed it under penalty of perjury saying that all their stuff is bullshit. And then I felt confident going into depositions, waving her, hypothetical around because I knew I had her in my back pocket, right? Those are traps. Those are traps because I know that they're not going to want to fess up and say, yeah, I lied about what Dr. Gill said. They're going to come up with some bullshit thing. And I know the whole time I've got Dr. Gill already in my pocket. And when we get into trial, I'm going to play this bitch's testimony. And then I'm going to put Dr. Gill on live right behind it so the jury can see and make their own decision about who's telling the truth. Those are traps.
cool. All right, thank you.
Yeah. And that's generally the way I do that. I'm not able to set what you call traps. I'm not able to set that up in every single case, but in Raffalina's case, that was a really solid, clear example that, they were just lying about everything Dr. Gill said. And the idiots, it's actually really funny, their attorneys. I did this in like 4 different key depots. I'd whip out Dr. Gill. I'd say, well, what about Dr. Gill? What if she comes in and says you're a liar? And after one of those depots, I think it was a Susan Pender depot, at the end of it, out in the hallway, the attorney asked me, he said, so, have you talked to Dr. Gill? Do you have her or something? I said, well, dude, she's the only doctor you haven't deposed. Maybe you should. And they just never did.
Wow.
Never deposed her. And then when I put her on the stand, they were all freaked out. It was like, what the fuck, you guys? You knew this was coming.
Now, in depositions, do you have to disclose, as you're in the deposition, right before you get the deposition, like all your facts or all the areas you're going to go into?
No. The only depots where you have to disclose are the person most knowledgeable depots.
Cool.
Oh,
okay.
Excuse me. Yeah, it's the PMK depots. You have to tell the other side what categories or areas of inquiry you're going to want to talk about, because they're going to have to get an agency representative and prepare them to testify. So they need to be able to know generally, not specifically, but generally what it is you're going to ask about.
Now, the last thing, let's just say you were bluffing about Dr. Gill. You weren't, but what if you were? Could you do that just to see what they would say?
You could, I suppose, but I don't usually do that. I don't bluff.
You don't want to play your, just in case it's wrong. Okay.
No. If I don't have it, I don't use it.
Got it.
Yeah.
Okay. I appreciate it.
Cool. Well, unless anybody has anything else, that's been about an hour anyway, so it's probably about time to cut it. Unless there's a question. All right. Hearing crickets, I'm going to say good evening to all of you. Thank you very much for joining us tonight, and hope you guys have a good week. James has a stream coming on in about half an hour. I'm not going to be on it. We were traveling last week, and I'm actually pretty tired. still. But anyway, I'll see you guys probably Monday. I'll probably be live on Monday with the stream then. In the meantime, you guys have a great rest of your weekend, and I guess that's it.
Hey, Sean, do you think we're going to have office hours next week?
Should. Let me, hold on a second. Let me look at the calendar real quick. Make sure that I'm around. I know I have some out-of-state depositions coming up, but I don't know what day. So give me 1 second here. I gotta load up the calendar, and then I'll let you know. Hold on. Well, where is this thing? There we go. Calendar. Today's Sunday. So that would be the 14th, right? Yeah, I should be around on the 14th. It looks like I'm around on the 14th. Cool.
Thank you very much.
So yeah, oh God, excuse me, I'm tired. We should have office hours next Sunday. If we're not, then James will post a message, but we should be here.
Thank you.
Sure. You guys have a great rest of your weekend.